And welcome back to Legal Matters, everyone. I'm your host, Alan Jones, and with me now is Mark Brynteson, the managing attorney with the American law firm. This is a half-hour informational news call-in show devoted to a variety of legal topics. We have attorneys standing by now to take your call at the number on your screen. That's 815-394-1776. They'll be able to provide you with free information on your issue. The call is confidential, so pick up the phone now and call the American law firm throughout the next hour. Again, that number, 815-394-1776. Now, our opening statement, how to select a personal attorney. Very important question. Then after a break, we'll be answering that age-old question, are you ever too young to start an estate plan? But first, let's remind you of the multiple practice areas in which the American law firm concentrates. The American law firm can assist you in a variety of legal matters, such as divorce and family law, bankruptcy, personal injury claims, criminal, traffic, and DUI issues, wills, trust, and probate matters, real estate and business transactions, and much more. So again, please feel free to call and discuss any of these practice areas with all of the attorneys standing by. The number on your screen, 815-394-1776. Lawyers are standing by right now to take your call. And again, the call is confidential. So Mark, welcome to the show. Good to see you as always.
Good to see you again. Yeah.
We have a lot of information to talk about today. It's very difficult in choosing an attorney, no matter what the issue. But if you're dealing with an insurance company, I guess the criteria, the question is, what kind of attorney are you looking for that the insurance company may not want you to have?
Very good question, and to rephrase it maybe is, what type of an attorney would they prefer you to hire? They would prefer you to hire an attorney that has never been to court, never tried a case, doesn't have any references from clients that can say this guy did a good job. When you go in and see an attorney, some of the things you should ask them, and I'll put it in the personal injury category, but this could be in any type of area of law. Ask the attorney, how many times do they go to court every week? How many cases do they try every year? Get a list of their verdicts, of cases they've actually taken to verdict, and what were they? Ask for a listing of clients. I actually have, now you can get into some confidentiality issues, but I have some clients, many clients, that they're okay with me giving prospective clients their name and number and calling them up to get a recommendation. Attorneys should be willing to do that, and you should be able to call, I would say, at least 3 to 4 to 5 clients that would give you good recommendations, because over that sample, that means they're doing a good job. If you call 5 and 2 of them say they wouldn't go back there again, that's probably an indication that they don't do a very good job. The other thing that you should really quiz the attorney on also is, what's their office practices and procedures? What do they have? Do they have automated practice management systems that can basically be paperless? How do they track your case? How do they make sure that you don't miss deadlines? Statute of limitations, for instance, in a personal injury case, generally have 2 years to file suit from the date you were hurt. How do they track that? We have a practice management computerized system that not only do we put that date in there, but we have many reminders coming up to that date. Going to court. Making sure you don't miss court dates. You want to know what type of systems are in place for that attorney to make sure that they manage your case well. Ask them. Ask them to show you. Also, see what type of staff they have. How long is the people that are working for the attorney, how long have they been there? How competent are they? How long has an associate attorney, if they're there, been practicing? Do they have a paralegal? What's their out front desk staff that meets the client? Like for me, I have an associate that works for me that does a lot of the personal injury work on the files. I have a paralegal, and that associate and that paralegal work together. I meet pretty much every day. The list of clients and the work we have to do on our practice management system comes up, so we can see what needs to be done, assign it, and then we have check-offs, and then we reschedule it for the next time. So you need to make sure that they have a staff that's competent to handle your case also, because the insurance companies know who the attorneys are that have these systems in place. They also know who the attorneys are that don't. So find out before you hire them.
Well, I guess a lot of that is common sense, but probably a lot of people don't do that. They go in and they talk to an attorney. Yeah, can you take the case? Sure, we'll take the case, but don't really bother to investigate an attorney. But that seems to be the smartest thing to do.
Well, I'll even tell clients when they come in the first time, look, I'm not going to put your arm behind your back and force you to hire me. If you want to go out and make other calls and compare me, go ahead. I encourage it. I've written a lot of books, a lot of brochures on personal injury cases, what they're involved. We'll give you free information, free literature. One of the other things I think you should look for as a potential client is ask the attorney about the fee schedule. We charge a third for personal injury cases. Sometimes it's appropriate to charge 40 if it's a complex med-mal case that's going to take many years. But if they're charging more than a third, you got to really look at it. So there are many questions that you need to look at as the consumer in hiring an attorney.
Okay, so in an American law firm case, you have a free consultation. That's the time to spend as much time as possible and get as many answers as you can right there.
And give us a call, 815-394-1776. We'll be glad to talk to you.
All right, sounds great. Well, we're going to take a break. When we come back, we'll discuss the age limits of estate planning. What are they? And are there any at all? Stay with us. We'll be right back. Welcome back, everyone. I'm your host, Alan Jones. With me, Attorney Mark Brynteson with the American Law Firm. You're watching Legal Matters, an informational and news call-in show devoted to a variety of legal topics. Attorneys are standing by right now to take your call at the number on your screen. It's 815-394-1776. They'll provide you with free information on your issue, and remember, the call is confidential. So pick up the phone now and call the American Law Firm throughout the next hour. Again, the phone number, 815-394-1776. Okay, Mark, you're kind of switching gears a little bit now. Let's talk about estate planning. Most people do that, maybe when they're older, but younger is the best time to start, right?
Actually, it is. I can give a personal example. My wife and I was 26, she was 24 when we got married. Our first child came when I was 29 and she was 26. And we did our estate plan when I was about 32, 33 years old. And in the estate plan, we did a trust. We debated a will or a trust because it was better for us. But the key to us, and we were expecting our second child at the time, was if anything happened to both of us, let's say my wife and I were going to a movie, and somebody went through a red light, creamed us, and killed us both. What would happen? What would happen to our kids? Mm-hmm. So when you have small kids, you start asking that, even though we were in our early 30s. So the question came up is, who would we want to have our kids if something happened to us while we were young? Who would take care of them and raise the children? And in the trust, you can provide an estate planning document for that very contingency. We had in our trust not only who would get what, but we said if something happened to both of us, here is who we wanted to take care of our kids. First, it was my mom and dad. They were first up. If they weren't around, then it was my in-laws. Mm-hmm. If they weren't around, then it was my aunt and uncle. My aunt just happened to be my dad's sister, who's only a year and a half older than I am. So we had that there. Now, as my parents got older, and this is a nice thing about a trust, as they got older, it came to the point in time, and we had 4 kids where they were retired. They shouldn't be the ones watching them, so we changed it. My brother was married and had kids, so we put him first. We put my wife's brother and his wife second, and then we had still my aunt and uncle third. So the kids were taken care of regardless of what happened, and that's just one little aspect of when you're young, why it's important to have that taken care of, because if it's not, and you die without anything there, the state will determine who gets your child. And it's not the state per se, but it's state law as interpreted by a judge.
Mm-hmm. And it's a changing document. I mean, I know we talked about there were several documents that go into estate planning and all that, but it is, or advanced care rather, but it is a changing, breathing document. You can change it at any time. You can make adjustments to it as you have. So how often should you actually readjust or reassess your estate plan?
Excellent question. In an estate plan, you usually have several documents. You can have the trust or the will. Well, there's 2 points in time that are important regarding estate planning documents. One is pre-death, that's before you die. Let's say I go out of here today and I go through an intersection, somebody blows through a red light, hits me, and I'm in a coma. I'm alive, but I'm in a coma, I'm incapacitated. How can somebody make my health care decisions, my financial decisions for me? My wife has a health care power of attorney, and she has a financial power of attorney, so she can take care of all that stuff if that were to happen to me. I also have a living will. Let's say, for instance, I'm in the coma and the doctors determine I'm brain dead. Well, the living will is read in conjunction with the healthcare power of attorney, and that gives my wife the authority to pull the plug, so to speak, if I'm not going to come back. So those are pre-death documents. The post-death, the ones that say who gets what, that would be a trust or a will. Most people, a will is fine. Others may want a trust. The whole goal to estate planning is a probate avoidance. A trust, if you get everything in the trust before you die, you can give everything away without probate, assuming that it's titled in the trust. The other parts is you like to give all your cash away, if you can, on payable and death accounts directly to the person. So estate planning, yeah, there's so much, the ability to be very flexible and change as you get older is quite simple.
Is that key?
Very easy, right?
Okay. Well, that's obviously, again, something you need to go over with an attorney, somebody in your family you need to talk about as a couple. All right. Thank you, Mark. Thanks for your time and insight. Once again, lawyers from the American law firm are standing by, so call the number on your screen, 815-394-1776. We'll be back in closing thoughts in just a moment.